Israeli occupation is unlawful under international law because it's not temporary, because the aim of the occupation is the annexation of the Palestinian territory. What does this mean? It means that every single conduct by the Israeli authority that is carried out, undertaken for security purposes, is unlawful under international law. So it's not clear why Netanyahu would have immunity for this state, but not Putin, who is still a president of another state. It's again the usual double standards policy, which so far, in my personal views, has been one of the main causes behind the commission of the most serious violation of international law. What we have seen in particular since October 2023 is that there are international law instruments, they are there, but the problem again is not international law itself, is states' lack of political will. I think that states maybe believe that they are undermining international law instruments only in relation to the situation in Palestine. I think what they are underestimating is that they are destroying the international legal order in every part of the world.
Welcome to the Floodgate podcast, brought to you by the Palestine Chronicle. We are here to engage with today's most pressing issues and unpack them beyond the cliches of mainstream media. I'm your host, Romana Rubio. Today's guest is Professor Triestino Mariniello. Mariniello is a professor at Liverpool John Moore University. His research interests focus on international criminal law, international humanitarian law, and international human rights law. Triestino Mariniello's academic writing has also appeared in a variety of leading journals in international criminal law. He has been consulted as an expert in international criminal justice and human rights by governmental and non-governmental organizations. Mariniello is also a member of the legal team representing Gaza victims before the International Criminal Court. Thank you so much for taking the time, and for the rest of our conversation, if you don't mind, I will call you Triestino.
Yes, of course. Many thanks, Roman. I'm very happy to join the podcast with you today.
Thank you. And I would like to start with the basics. So before we dive into the current situation, I think it is important to make sure that everyone is clear on a few definitions. Could you very briefly explain what the International Court of Justice, ICJ, is, and what the International Criminal Court, ICC, is, and why they're different? Because I think a lot of people hear these names tossed around, but the distinction between the two, of course, is crucial.
Yes, I mean, very briefly, without going into technical discussions, the International Court of Justice is the maximum judicial bodies of the United Nations. It has competence in relation to states' responsibility. So, in contrast to the International Criminal Court, the International Court of Justice does not deal with individual criminal responsibility, but in other words, it deals with the potential violation of international law by states. On the other side, we have the International Criminal Court, which is not a UN body. It's an independent body created by states in 1998 in Rome. And as I said, in contrast to the International Court of Justice, it deals with individual criminal responsibility. In other words, it has competence over individuals allegedly responsible of war crimes, genocide, crimes against humanity, and potentially the crime of aggression.
Thank you, Triestino. That was very clear. And now moving to the current war, what is happening right now at the level of international law? We know that South Africa filed a case against Israel at the ICJ, accusing it of violating the Genocide Convention. Meanwhile, at the ICC, arrest warrants were issued for both Palestinian and Israeli leaders. Since then, though, every single Palestinian leader on that list has been assassinated by Israel, while the arrest warrants against Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant are still standing. So where do things stand today? What's moving, if anything, and what should we be paying attention to now?
Yes, I mean, so since October 2023, there have been quite a few proceedings ongoing before the International Court of Justice, and also, as you correctly said, Romana, before the International Criminal Court. With regards to the International Court of Justice, first of all, South Africa has brought a case against Israel for the violation of the Genocide Convention in 2024. So, on three different occasions, the International Court of Justice has found that it's plausible that Israel is committing genocide in the Gaza Strip. In other words, it's violating the Genocide Convention of 1948 and has imposed provisional measures on the Israeli authorities. So far, Israel has not complied with any of the provisional measures imposed by the International Court of Justice. Just to make it clear, under international law, these provisional measures are legally binding. In other words, states do not have any discretion in whether or not complying, respecting such provisional measures. I mean, among these measures, there was, for instance, the possibility to enable the access of humanitarian essential goods into the Gaza Strip, which, as we know, so far Israel has not respected at all this measure. Maybe the only measure that Israel has complied with has been to submit a report before the International Court of Justice, but this report has been kept confidential, so we don't know what Israel has brought in its documents to the International Court of Justice. Then in July 2024, there has been another important development at the International Court of Justice, and which is the decision, the advisory opinion of the ICJ on the illegal occupation. In other words, for the first time ever, following a resolution by the General Assembly, the International Court of Justice has concluded that the occupation, the Israeli occupation, is unlawful under international law because it's not temporary, because the aim of the occupation is the annexation of the Palestinian territory. What does this mean? It means that every single conduct by the Israeli authority that is carried out, undertaken for security purposes, is unlawful under international law because it's undertaken within a context of a lawful occupation. So Israel cannot lawfully put in place any activity, any military operation as well within the occupied territory because the entire occupation again is unlawful. And then on the other side, a few hundred meters from the International Court of Justice, we have had these significant developments at the International Criminal Court. In May 2024, the prosecutor Karim Khan requested arrest warrants against Netanyahu and Gallant and against Hamas political and military leaders. The proceedings against Hamas political and military leaders have been terminated because they have been killed by the Israeli authorities. So far, the only proceedings still undergoing open are the ones against Netanyahu and Gallant. In November 2024, the pretrial chamber of the International Criminal Court has issued arrest warrants for war crimes and crimes against humanity against them. So the current Prime Minister Netanyahu and the former Defense Minister Gallant. Among these charges, there are for instance, they are accused of the war crime of starvation. In other words, deliberately depriving Gaza civilians of essential goods. There is the war crime of intentionally directing attacks against civilians. So, as I said, as a war crime. Israel, for the first time ever, has decided to appear before the International Criminal Court. Well, not physically, but in other words, to submit its appeals, complaints in relation to the decision issued by the pretrial chamber, and has appealed before the appeals chamber the decisions of the pretrial chamber in relation to the arrest warrants, in relation to the dismissal of the jurisdiction of the trial chamber, because Israel has always argued that since it has not ratified the statute of the International Criminal Court, the ICC cannot exercise its jurisdiction, or cannot exercise its jurisdiction over Israeli nationals. So the most recent developments in this regard are the decisions, the judgments, to be more precise, of the appeals chamber of the ICC that has dismissed on one side Israel appeal, claiming that the prosecutor should have sent another notification, as also the Palestine Chronicle wrote, to the Israeli authorities, and has partially accepted another appeal of Israel in relation to the jurisdiction. What does this mean? It means that now the trial chamber has to decide, in relation to the substance of this complaint, decide whether or not the court has jurisdiction. So, in other words, the court has decided that Israel has this standing, this right to submit this complaint. As I already said, in practical terms, this does not mean a lot, to be honest, because in any case, Netanyahu and Gallant, individually, they had this right. Now, the appeals chamber has recognized that Israel has this right as well. But, as we are talking about the prime minister as the accused here, it does not really change a lot. So, in practical terms, this acceptance of one of the complaints submitted by Israel won't have any effects. Just to conclude this discussion, as we are discussing about the ICC, we should also add that a few states, unfortunately, I'm talking of Western states, have said publicly that they are not going to implement such arrest warrants against Netanyahu in particular. From a legal perspective, this is absolutely unacceptable, because it's a violation of the obligations that these states have under the statute of the International Criminal Court. The clear example here is Hungary, that has welcomed the visit of Netanyahu. Hungary is so far, and it will be for 1 year at least, because it has announced its withdrawal from the statute of the International Criminal Court, but Hungary still had the legal obligation to arrest and surrender Netanyahu to The Hague. Indeed, the trial chamber now, just a couple of days ago, has opened proceedings against Hungary for potential violation of the Rome Statute, violation of duty of cooperation with the ICC. But we have seen at the same time other Western EU member states, I'm referring to Italy, Germany, Netherlands, Belgium, and also France, saying that in any case they will not implement, if they had the possibility, to the arrest warrants against Netanyahu because he has immunity. These are clear examples of double standards. All these cases have been strongly supporting the intervention of the ICC in Ukraine, which just to remind everyone, the ICC has issued arrest warrants against Putin. So it's not clear why Netanyahu would have immunity for this state, but not Putin, who is still a president of another state. It's again the usual double standards policy, which so far, in my personal views, has been one of the main causes of behind the commission of the most serious violation of international law by the Israeli Authority in Gaza, but overall in the entire Palestinian occupied territory.
And we will, of course, come back to this, Triestino, because it's very important. But one question that, comes to my mind now is that even legally possible? Like when politicians say that they won't enforce, for example, an ICC arrest warrant, for example, against Netanyahu, or does the responsibility fall on the judiciary of each country, no matter what politicians say? This is a point that, is very often debated, and it's not very clear for the larger audience.
This is a crucial issue, and the answer is it depends. It's a case-by-case assessment. So there are countries, and this is, for instance, the clear example is Italy in this regard, where the governments do not have any discretions in relation to the implementation of the arrest warrants. So there are other countries in which there is a discretion given to the members, individual members of the government, or the government, to the executive power themselves. If we look at this from the perspective of the Rome Statute itself, there should be no discretion. because once states have decided to ratify the statute of the International Criminal Court, they have already renounced voluntarily to this discretion, because they have accepted the intervention of the ICC, and so they have accepted that the ICC is replacing these states, every state, in exercising their jurisdiction when there is no alternative, when no state is doing it, in other words. So, as in this case, since Israel is not doing, is unwilling and unable to put in place any genuine investigation against Israeli political and military leaders, it can be only the ICC to exercise, only the ICC has the possibility to exercise such a jurisdiction. So from the Rome Statute itself perspective, there should not be such discretion. However, in national laws implementing the Rome Statute, some countries may have introduced this discretion, which appears particularly problematic. But what we are seeing now is, and I go back to what I was saying before, is also in those countries in which there is no political discretion at all, even from internal legislation point of view, states, governments are claiming they have this discretion. The clear case again here is Italy, because Italy has recently not implemented an arrest warrant in another context, in the situation in Libya, deciding not to transfer to the Hague al-Masri accused of international crimes in relation to the situation in Libya for crimes committed against migrants, asylum seekers in Libya. And in this case, Italy has claimed that there is a political discretion of the Minister of Justice, which does not have any legal basis in international law, but also in domestic law. But this will be the same also in relation to other countries that are claiming this discretion. For instance, France will be another clear example of this.
And before we move to the broader context here, I just want to have a follow-up of something you said. So in recent days, we discussed two pieces of news. One was the fact that some misleading media reports said that the decision by the ICC to issue arrest warrants had been reversed. And you already said this is not true. The ICC arrest warrants are still standing. And we also had an interview with you, Triestino, in the Palestine Chronicle a few days ago that I will link here. But there is another decision by the ICJ, and I would like you to explain what it actually means in practice. The ICJ granted Israel a 6-month delay. What does it mean? In which terms?
So let's start from the ICC. As I said before, I mean, in practice, this decision does not have any effect. Maybe we will see in the next few weeks and months, states politically using this decision. They will say, the ICC is revising the jurisdiction, so we are not going to implement arrest warrants. But this will be really, if I can label it as a political abuse of the work of the judicial decisions, because this is not what the appeals chamber said. The issue before the appeals chamber was merely procedural. The appeals chamber has only decided that Israel has the standing as a non-state party to challenge the jurisdiction of the ICC before arrest warrants were issued. That's all. So Israel had this standing. The statute in this regard is not clear when it comes to a non-state party. And now this is the clarification. Now it's up to the pretrial chamber to decide whether or not this challenge is legally founded or not. I mean, if I can predict my personal conclusion of the pretrial chamber on this, I will say that I will be very, very surprised if the pretrial chamber were going to accept the challenge to the jurisdiction, because the pretrial chamber in the past has already clearly said that it has jurisdiction over this. Maybe the court is going now to look into in greater details the issue related to the Oslo agreements and the impact this may have on the jurisdiction of the International Criminal Court. It's an argument that Israel has always raised, but as we have said even before the International Criminal Court, this is legally completely unfounded. So I think that it's extremely likely that the pretrial chamber, looking into the substance of Israel's complaint, is going to reject this and decide that the court has jurisdiction over this. So in practice, as you say, the arrest warrants are still valid. There is no point, no section, no sentence in the appeal decision saying anything in the other way around or placing into the question the validity of the arrest warrants. Israel was explicitly requesting this, and the appeals chamber has explicitly rejected this request. So this is what the appeals chamber judgments say, both of them. In relation to International Court of Justice, yes, that's correct as well. Just very recently, a few weeks ago, the International Court of Justice has granted to the Israeli Authority this extension in relation to the proceedings brought by South Africa against Israel, we were mentioning before, for violation of the Genocide Convention. Israel was supposed to submit its counter arguments, its documents in reply, so to the South Africa submission very soon. But the extension given is an extension of 6 months, so which means that Israel has, if I'm not wrong, until January 2026 to submit its own materials, document, information in relation, its response, to say it better, to these to South African arguments in this case, and also arguments raised by other organizations and states. I mean, to be honest, I think this decision of the International Court of Justice appears particularly concerning and even surprising, to be honest, because it has to be analyzed in light of the context, and the context is the situation in Gaza, of course. So the court that is granting this extension while a genocide is ongoing in the Gaza Strip, so where there is now huge evidence that Israel is violating the Genocide Convention, it's not really very clear from a legal perspective why this extension has been granted, to be honest, considering also that Israel has had plenty of time, procedurally speaking, to prepare its response in this case and to submit all its evidence or alleged evidence. I mean, and when I say there is really huge evidence concerning genocide, generally the most difficult element, as you know it very well, to prove in genocide is the so-called genocidal intent, the intent to destroy in whole or in part a protected group. I mean, even in these past few days or weeks, we have plenty of statements by members of the government showing a clear genocidal intent. Just let's read, for instance, the defense minister's statements, most recent statements in relation to the situation in Gaza. To my memory, in the past 30 years, there has never been so clear evidence of genocidal intent. Genocidal intent, then it's clearly implemented into the Gaza Strip. It's not just are not just words, you know, which is already enough, because for the Genocide Convention, I mean, it's already enough. You need to prove that intent is in place, not actually genocide has taken place. And I would also like to remind everyone that the Convention of Genocide is also called Convention on the Prevention of Genocide. So even if there is someone out there still thinking that the genocide is not in place, this does not mean that the protection under the Genocide Convention cannot be triggered, activated at this stage. Because one of the purposes of the convention is to prevent the commission of genocide. And since the International Court of Justice has already said on 3 different occasions that there is a risk of genocide, it's plausible that genocide is being committed, why granting this extension now? To be honest, it's really, again, I would like to highlight this. From a legal perspective, it's very difficult to understand why.
The rationale behind it, absolutely.
Exactly.
Also because, Triestino, of course, these legal cases, but in general, these issues did not just start on October 7, 2023. There is a much deeper context of violations here that often gets either left out or misrepresented. For example, you were already representing victims from Gaza well before October 2023. So can you tell us more about that longer timeline and why it is important to understand the background to these cases, especially when it comes to Palestine and Gaza in particular?
Well, of course, I mean, very briefly, will require much longer time. I mean, State of Palestine engagement with the ICC started in 2009 after the military operation Cast-led in the Gaza Strip, one of the military operations in the Gaza Strip, when Palestine for the first time accepted the jurisdiction of the ICC. There has never been an investigation for political reasons. The first prosecutor of the ICC was subject to pressure by the United States, and in contrast to other prosecutors, he accepted this pressure and decided not to open an investigation. But then the state of Palestine went back to the ICC in 2014 after another military operation, Protective Age, and then there was an investigation opened by the former prosecutor Bensouda in relation to war crimes committed by the Israeli Authority, also by Israeli Authority in the Gaza Strip during this military operation, but also in relation to the situation in the West Bank, settlements, and also in relation to the Great March of Return, war crimes committed within the context of the Great March of Return in the Gaza Strip. The problem here is that all this already open investigation seems that has been ignored by the current prosecutor of the International Criminal Court when he took office, but also when he has actually started to put in place an effective investigation. It seems, and this is one of the concerns that as legal representative of victims we have, that, I mean, we welcomed with huge enthusiasm the decision to open an investigation, in particular to request arrest warrants, but still today we are very concerned that there is so far no reference in this investigation to international crimes committed both in the West Bank, including Jerusalem, and in Gaza Strip before October 2023. We are very concerned for a number of reasons, because it excludes Palestinian victims from the access to the ICC, victims of previous crimes committed before October 2023. But also I'm concerned because it provides indirect legitimacy to the dangerous narrative that everything started in October 2023, and does not place this investigation, at least so far, proper attention, emphasis on the context itself, and the context of the unlawful occupation in the West Bank, including East Jerusalem, and on the Gaza Strip. The occupation itself, the blockade of Gaza, that as I always emphasize, in the last 70 years, the blockade of Gaza itself, without looking at any context, constitutes, under international criminal law, in my views, a crime against humanity itself. So far, unfortunately, in this investigation, there is no proper reference to the context that you correctly, mentioned before as well. In other words, this is a discussion I think we also had in the past with the Palestine Chronicle. Once again, we have to raise this issue of the narrow scope of the ongoing investigation. And the narrow scope so concerns the crimes that are excluded so far by the investigations, and I'm referring in particular to genocide. Because as we said, there is huge evidence in relation to this crime, and it's not part of the investigation. The wider scope concerns also the territorial jurisdiction of the court, why there is no investigation, why there are no arrest warrants requested yet in relation to the situation in the West Bank, including East Jerusalem, considering what's happening also while we are talking in that territory. And why there are not yet arrest warrants against other Israeli political and military leaders. One of the crucial questions here is why no arrest warrants against any senior official from the IDF? Again, if this is not going to happen in the near future, this entails the risk, this narrow scope, to provide, again, indirect legitimacy here to a very dangerous narrative, and to send a very dangerous message, which is that we are dealing here with a moral army, as someone would like to label it, and the responsibility just belongs to two individuals, but then who are complying allegedly with orders. So what must happen, in my views, in the very near future is a widening of the scope of an investigation, which means further charges of international crimes, first of all of genocide. Sorry to be repetitive, but I think this is extremely important. And other individuals, from members of the government and also, senior officials from the IDF.
Also, because I think rarely we have had so much evidence of war crimes committed and crimes against humanity. And as you said, the statements, reiterating the genocidal intent, even extremist ministers like Itamar Ben-Gvir saying we need to bomb every food warehouse in Gaza. Like, there is nothing left for imagination here. But let's talk about the elephant in the room. Even from what we said so far, there is a lot of skepticism right now about the international system itself. And it's true that some of the steps that have been taken were almost unthinkable a few years ago, let's be honest here. But at the same time, people still feel that it is too little too late. And you said it too, especially given the scale of what is happening in Gaza. When you compare this to how quickly international courts have acted in other cases, especially involving countries in the global south, the question, of course, becomes unavoidable. Are these institutions really neutral, or are they politically influenced? And when they are supposed to be upholding international law? Recently, we interviewed Professor Richard Falk, who said they were deliberately created vulnerable from an enforcement point of view. So the enforcement mechanism wasn't implemented in a way that could make these institutions strong enough. What is your take on this?
Yes, I mean, if I can just as you mentioned, just to go back very briefly to the previous question, as you mentioned Ben-Gvir, and I was talking of the arrest warrants, SEC arrest warrants. I mean, I mentioned genocide, but another clear example is potential commission of international crimes against Palestinian detainees, prisoners, and the widely documented use of torture techniques as a war crime and crime against humanity. In that case, the responsibility of Ben-Gvir, would be one of maybe the first one coming to the attention of the ICC. And again, we don't have any investigation in this regard, at least public, that any request of arrest warrants, which are public. I mean, moving to your question now, I mean, I cannot but agree with Professor Falk. These institutions have been created as vulnerable because on one side, states decided to run to part of their sovereignty when it comes to the ICC in criminal justice affairs, but on the other side, they did not provide the ICC with, as you correctly said, with independent enforcement mechanism. What does this mean in practice? It means that the court needs states cooperation. States cooperation depends on political will of states, of course, to even, implement some decision that in a domestic context will not be very difficult in theory to implement, like the one of an arrest warrant. The court does not have its own police, does not have its own army, so it depends on states for the implementation. But just to make it clear, this is not a problem, and I'm sure Professor Falk would agree on this. This is not only a problem of the ICC or the ICJ. This is a problem of international law itself. I mean, most of international law instruments can be enforced only with state support. So if there is no state support, they cannot be implemented. I mean, we can really provide a lot of examples in very different fields, from human rights law to international criminal law, to state responsibility, like in the case of the International Court of Justice. What we have seen in particular since, this is in my personal view, since October 2023, is that there are international law instruments, they are there, and they have shown that they can be used in specific contexts, like in very difficult contexts like this one in the Israeli-Palestinian setting. But the problem again is not international law itself, is states' lack of political will, intent to implement such, in contrast to their obligation under international law. In other words, what states have done so far with their clear policy of double standards has been to undermine completely. I think that states maybe believe that they are undermining international law instruments, only in relation to the situation in Palestine. I think what they are underestimating is that they are destroying completely the international legal order in every part of the world. Today, the victim of this destruction of the legal system is Palestine, but tomorrow will be other people in other contexts.
Absolutely. And, sometimes they say that Western countries do not do enough to stop the genocide, but in actuality, their inaction is actually an active, help and support they give to Israel for the reasons you were mentioning. But one of the, voices who were more vocal regarding this war on Gaza and the humanitarian catastrophe was late Pope Francis. And I read, Triestino, that you and Raji Sourani, who is a prominent Palestinian human rights lawyer, the director of the Palestinian Center for Human Rights and legal representative of Gaza victims at the ICC, were supposed to meet with Pope Francis. And we know that the late Pope has been, not only vocal, but he had asked to investigate into the genocide, the Israeli genocide on Gaza.
Yes, I mean, within the context of what the late Pope said in November, I think it was on 17th of November 2024, to investigate whether or not in Gaza there is an ongoing genocide, Bergoglio decided to invite me and my colleague Raji Sourani, as you said, also legal representative of Gaza victims before the International Criminal Court. But Raji is also a survivor of the Gaza war. I mean, his house has been bombed on different occasions, but he managed to flee. First of all, in order to have a factual analysis on what's going on in Gaza, but at the same time to have a legal discussion in relation to whether, as he said, this can be under international law classified genocide. Unfortunately, the meeting was never held because of the Pope's health conditions. But this is exactly what we would have told him: why there is an ongoing genocide. We would have talked with him following his request of our work for Palestinian victims and for their families before the International Criminal Court, but also the work of the Palestinian Center for Human Rights before the International Court of Justice. I think that the proposal to have this private hearing was another sign of the late Pope commitments to the protection of Palestinians in the Gaza Strip, but more in general to the role that international law can play in protecting, population under occupation, under military invasion, like the one in Gaza. So the hope is that the new head of state, if I can add this, of Vatican, will have the same attention to the ongoing genocide in the Gaza Strip. Just going back to what you said before, sorry for this, you mentioned the inaction of states. I think, and I'm sure we fully agree on this, that I will not use, this term inaction of states, because what we are seeing here is not really inaction of Western states. The Western states are acting. The West, even while we are talking, they are still transferring weapons to Israel. This applies to Germany, this applies to the UK, this applies to Italy, So they're acting. And one of the reasons why they are not complying with international law instruments is because they are also responsible in the ongoing commission of genocide in the Gaza Strip. Because the transfer of weapons, when you already know, you are aware there is a risk of genocide, there is an ongoing genocide, it also entails your responsibility in this regard. So they are acting, but they are acting again in complete violation of international law.
Absolutely. And looking ahead from a factual and legal perspective, what is next? And also, do you think that civil society can play a role here? For example, we have seen initiatives like the Hind Rajab Foundation, where
Yes.
this foundation is actively tracking and identifying soldiers involved in war crimes in Gaza. So could that kind of grassroots initiatives and documentation actually have an impact? I think this is really important. Like, what is also our personal responsibility as civil society? What can we do practically to move things forward?
Yes, I mean, that's a great point. You raised the work done by the Hindi Rajab Foundation. There are a lot of organizations, or individual lawyers, human rights lawyers, criminal lawyers, bringing a case under the so-called universal jurisdiction, or on the basis of double nationality of members of the IDF. Just a few days ago, in London, it has been brought a case, a criminal case against to Scotland Yard against 10 British nationals, and in this case also the Palestinian Center of Human Rights is involved. We are talking of 10 double nationals, so they who also members of the IDF who also are British nationals. And at the same time, in a number of countries, there are similar initiatives ongoing. I think this is crucial. I mean, I think it's very important that we assist to an increase of these cases brought before national authorities. And in this regard, the role of civil society organizations, human rights groups, individual lawyers is fundamental. Like we have seen also in other contexts, we have seen in relation to situation in Syria, for instance, or in other situations, it's important. It's much more difficult that these cases are successful when it comes to the involvement of Israeli political military leaders, because double standards do not operate only on a political level. They also operate on judicial level, and judiciary are under incredibly high political pressures when it comes again to the potential responsibility of Israeli nationals. But this does not mean that these initiatives are useless. I think that in the medium and long term, they will have a lot of effects that even for us are difficult to predict at this stage. Of course, if one believes that these legal initiatives are the ones now stopping in the short term the genocide, I think this will be quite naive, to be honest. I mean, this belongs to political decisions. I mean, we are talking of the role of international law, of international instruments, but here we should also say a few words on which are the expectations we have in relation to international law. And there is no precedent here in which international law has brought to liberation of people's population in any part of the world. This liberation does not occur without political intent, without a strong role of civil society, like in the case of South Africa and the apartheid regime of South Africa. So I fully understand all the skepticism in relation to international law instruments in light of the ongoing genocide. But again, I think it's important, especially for international lawyers, to make clear when we meet with civil society, which are the expectations that we should have from international law. Of course, one of the correct expectation, if I can use this word, correct expectation, is putting an end to impunity is an important step. We are already seeing some of the effects. Netanyahu cannot travel to most of the countries in the world because of this. So his role as prime minister is already reduced. And who knows what is going to happen if he will be arrested and surrendered. I'm sure that in the medium term, as I said, we will see much more concrete effect, which is not enough to stop the ongoing genocide. This belongs a lot to the political role. Sorry.
And yeah, I think we should keep, putting pressure on our governments to take their own responsibility in the face of what is happening in Gaza. Thank you very much, Triestino Mariniello, for taking the time to speak with us and for your unwavering dedication to justice in Palestine and around the world. And to all our viewers, we appreciate you tuning in. As many of you already know, the Palestine Chronicle is heavily censored on social media. The best way to push back against censorship is to engage directly with our content. So please like, share, comment, and follow. We look forward to seeing you in the next episode of the Floodgate podcast. Thank you.